May I request that the participants please rise as the dignitaries enter the premises. Please take your seats. A very good morning to our distinguished guests, speakers, ladies and gentlemen. Welcome back to day 3 of the Bengaluru ADR week. We thank you once again for making time on a Sunday morning to come and participate and be a part of some interesting and burning discussions that require your participation. We hope to keep you engaged with an interesting session of discussions and, of course, leading up to the main event, which is the great parliamentary debate. Today's panel discussion will discuss an incredibly important and arguably what is a burning issue of the government's withdrawal from arbitration and its implications for dispute resolution and policy in India. To deliberate on this really critical theme, we have an esteemed and a stellar panel of speakers today representing the bench, the bar, and more critically, the government, which is why we will have an all-encompassing series of perspectives on why the government is deciding to do what it is doing. To introduce the speakers, I would like to invite Ms. Lakshmi Menon onto the stage, please.
Ladies and gentlemen, good morning. It's my honor and privilege to introduce before this gathering our august panelists for this morning session. Honorable Shri Justice S.R. Krishna Kumar. Justice Krishna Kumar enrolled as an advocate in the year 1992. Prior to his elevation in 2019, his lordship practiced as an advocate before the Honorable High Court of Karnataka, as well as civil and criminal courts and other tribunals in Karnataka. Aside his astute sense of justice, fairness, and the ability to disperse equity to all those who appear in front of him, Justice Kumar is known for his patience, especially when hearing arguments of nervous young members of the bar, and his ability to simplify complex commercial matters and render fair and balanced judgments. Thank you, sir, for being with us. Shri Arvind Kamath, a designated senior advocate and the Additional Solicitor General of India for the High Court of Karnataka. Post his enrollment, Mr. Kamath practiced across courts in Karnataka and thereafter founded ALMT, a full-fledged law service. As Additional Solicitor General, Mr. Kamath appears for and defends the Government of India and its departments and agencies in the High Court of Karnataka as well as other courts and tribunals. Thank you, sir. Ms. Purnima Hatti, Partner, Samvad Partners. Ms. Hatti is a well-recognized litigator and also regularly serves as an arbitrator and mediator. She has acted on behalf of Indian and foreign clients in complex commercial litigations before the Indian courts, quasi-judicial authorities, and in arbitral proceedings. She is associated with various organizations, including the Singapore International Mediation Center, where she is an India specialist mediator. Ms. Hatti is a visiting faculty member at the National Law School of India University and a guest lecturer at IIM Bengaluru, and is a member of the LCIA Young International Arbitration Group and the Australian Forum of International Arbitration, the Indian Arbitration Forum, etc. It is our honor, ma'am, to have you with us today. Shri Kiran Ron, AAG Government of Karnataka. Mr. Ron is one of the founding partners of Lex Plexus, a boutique law firm based in Bengaluru. He has been practicing over 26 years and has represented clients across a broad spectrum of legal issues, including civil, corporate, constitutional, forest, land acquisition, and arbitration matters. Mr. Ron currently serves as the Additional Advocate General for the state of Karnataka. Thank you so much, sir, for being with us today. Shri Anand Thomas, Partner, AZB Partners. Mr. Thomas is a partner who has spent over 20 years of experience advising and representing clients across various sectors, including but not limited to the information technology, telecommunications, and data privacy and protection domains. An alumnus of the National Law School of India University, Anand regularly acts as counsel in various domestic and international arbitrations and represents clients in various fora, including the Honorable Supreme Court of India, High Courts, company law, and appellate tribunals. He also supports the mergers and acquisitions, joint ventures, and general corporate practices at EZB Partners. Thank you all for joining us here today, and we very much look forward to this engaging session. May I formally request Justice Krishna Kumar to take the panel discussion forward.
Good morning, everyone, and welcome to this session of the Bangalore ADR Week. It's my privilege to chair today's discussion on a subject that has generated intense debate across legal, policy, and commercial circles over the past year. The government's withdrawal from arbitration and what it means for the Indian dispute resolution ecosystem. We meet at a moment when India's arbitration landscape stands at crossroads. For nearly a decade, Parliament and Judiciary have worked together to modernize the Arbitration and Conciliation Act through successive amendments intended to make arbitration faster, more predictable, and internationally competitive. These reforms were meant to anchor India's aspiration to emerge as a preferred venue for high-quality arbitration. Yet, despite this legislative and judicial momentum, two major policy developments in the last few months have signaled a marked shift in approach. In June 2024, the Ministry of Finance issued guidelines restricting use of arbitration in government procurement to disputes below 10 crore rupees and directing that larger disputes be taken instead to mediation or to the courts. Later in November, the state of Karnataka issued a circular withdrawing the long-standing requirement that state contracts must contain a mandatory arbitration clause. Departments have now been instructed to rely upon internal mechanisms, mediation, or litigation for future disputes. Both these decisions appear to have been driven by a sentiment that arbitration has not delivered the benefits that were once expected. The government has noted concerns about large monetary awards, unpredictability in outcomes, lack of adequate oversight, and the growing reality that most awards end up being challenged, turning arbitration into the first stage of an extended litigation process. Officials also point to practical difficulties such as frequent transfers, limited continuity, and challenge to managing technically complex and long-running proceedings. At the same time, these developments have raised several important questions. What will this shift mean for India's ambition to establish itself as a global arbitration center? How will already overburdened courts manage an influx of high-value public works and infrastructure disputes if they move away from arbitration? Will this shift improve fairness and public accountability, or will it simply extend timelines and increase costs? And perhaps most importantly, what message does this send to investors about stability and predictability of dispute resolution in India? Now, certain problems are flagged. To understand this decision and analyze it as to why the government seeks to withdraw, we need to look into the problems faced by the government in depth to call out the reasoning behind its withdrawal. Number one, the government's unique decision-making structure. Government decisions are scrutinized by multiple oversight bodies, making officers risk-averse. Accepting an adverse award without appealing can attract audit objections or disciplinary concerns. This prevents arbitration from offering true finality for government disputes. As a result, arbitration becomes only a preliminary stage before inevitable court review. Number two, transfers and lack of continuity. Frequent transfers disrupt institutional memory, leaving officers unfamiliar with past negotiations and project details. This forces departments to rebuild facts from scratch each time a dispute arises. Arbitrations demand consistent technical engagement, which rotating officers cannot always provide. The state therefore enters proceedings at a disadvantage compared to stable private teams. Number three, time and cost overruns. Arbitrations today often stretch across 3 to 7 years, due to adjournments and scheduling delays. Costs escalate rapidly with arbitrator fees, expert charges, and document management expenses. For the government, the overall burden becomes comparable to or even higher than litigation. This undermines the core purpose of arbitration as a faster and cheap alternative. Number 5, erroneous or inconsistent awards. Arbitrators operate without structured training, accountability, or transparency applicable to judges. This sometimes leads to factual mistakes or legally inconsistent decisions, especially in technical cases. Awards are delivered privately, limiting public oversight or uniform development of standards. The government views this unpredictability as risky, especially for high-value public contracts. Number 5, arbitration becomes an extra layer of litigation. The expectation that awards bring finality rarely holds true for government disputes. Most significant awards are challenged under Section 34 and 37, adding years to court proceedings. This duplication means that the state fights the same dispute twice, increasing delays and costs. Instead of reducing judicial burden, arbitration ends up creating another procedural layer. Next, mediation viewed as a safer alternative. Mediation offers a collaborative and non-adversarial framework that suits government accountability norms. It's cheaper, quicker, and allows negotiated outcomes without the rigidity of arbitration. The statutory backing of a Mediation Act encompasses structured, transparent processes for public disputes. For the government, this reduces financial risk and avoids large, unpredictable awards. And lastly, Karnataka's financial concerns. The state highlighted the rising cost of arbitration, especially massive awards with escalating interest. These liabilities place substantial pressure on an already strained public exchequer. Challenging such awards prolongs financial uncertainty and drains administrative resources. Removing mandatory arbitration was therefore seen as a fiscally protective measure. Our esteemed panel today will examine these concerns with nuances and balances. The aim is not to advocate for one side, but to understand the motivations behind these decisions, analyze their legal and economic implications, and explore how India can strike a sensible balance between efficient dispute resolution and responsible public administration. It may well be that the solution lies somewhere in the middle, through calibrated use of arbitration for technical high-value disputes, greater emphasis on mediation for smaller matters, enhanced capacity within the government departments, and stronger mechanisms for accountability within the arbitration system. With that context, I look forward to a thoughtful and constructive conversation. Let's commence. I think we'll begin with the central government, because they were the first one who issued that circular. Right.
Yes, sir.
Learned ASG will start.
Yes, sir. Thank you. Let me begin by giving a quick reference to what happened in the Supreme Court sometime during September 2024, when there was a constitution bench which was hearing the case of Central Organization for Railway Electrification. That case dealt with a challenge to the composition of a panel of arbitrators by various PSUs. You had also rendered a judgment. So the constitution bench was dealing with that. And on behalf of the contractors' petitioner side, there were vociferous arguments made on the ground that it leads to bias. It's a curated panel. And I remember Chief Justice Chandrachud making a comment that he turned towards the petitioners and said, look here, if you make this entire arbitration too unattractive to the government, they may withdraw from it. And today, we have come to that actual situation. Sir, I feel we have to have a quick look at the background. You have covered some of them. Arbitration was introduced as an alternative dispute mechanism, having unique advantages over the conventional justice delivery system, because it was considered to have three distinct advantages. Number one, that it was thought to be very fast when compared to the overburdened courts. Number two, that there was no ad valorem fee, so it was cost effective. And number three, that there was some sort of a finality, that the arbitral tribunal is the final arbiter on facts, that there is no further challenge to it. But the practice has shown to us that there has been a lot of challenge in all these 3 years. Number one, it has not been as fast as we have thought, and particularly where there are panels of 3 arbitrators or more, getting dates has become very difficult. The more and more popular, celebrated arbitrators we have, getting dates from them, getting a common dates for 3 arbitrators, 2 senior counsel, and other counsel has been very difficult. So arbitrations have now gone beyond 3 years. Number two, when it comes to the cost, I think it has been completely counterproductive. Now, it's a big concern for the government and others is the huge arbitration cost, the fee that is levied. And now, in most cases, it's typically like engaging a senior counsel. The arbitrators appear or conduct proceedings for a limited 2 to 2.5 hours with a high fee. There are separate fees for reading, writing award, and various others. And thirdly, the finality aspect once again has suffered because almost every award gets challenged. There are multiple layers. You already mentioned about it. The fourth area was where arbitration was considered, where some technical people having technical knowledge, particularly in the 21st century, we have a disputes on technical side, like it could be infrastructure development, energy, telecommunication. So we need a technical expert. So one area where the government and PSUs felt that not gaining control over the result, but getting good arbitrators was forming their own panel. So they would go look for people, they would take a commitment from the arbitrators that you have the time. Number two, they would get a commitment that you are acceptable to our fee. So they are not surprised with a uncapped fee. And number three, they would find people from technical domain like railway safety or construction or energy, power supply. These. Now, if we, in the experience has shown that in most arbitrations, the biggest chunk of award always used to be award of damages. And I feel maybe having regard to the very liberal nature of arbitration, the informality involved in arbitration, and an element of informality has crept into, along with informality, an element of liberalism has also got into award of damages. The contractors claim a whole lot of damages like overhead, loss of profit, and some of these are about 50% of that is granted. So experience has shown that while the award is not so much for the unpaid bills, it is more so for the damages. Now, this experience was a big setback for the government. And somewhere around 2023, when the mediation bill was introduced, that was when, in June 2024, the central government came out with a circular, the Ministry of Finance. It captured all the issues that I just referred to and found that arbitration has not been a go-to kind of a forum. So therefore, it said, having regard to all these challenges, the department should prefer mediation, particularly after mediation was brought in by virtue of an act. And then finally, last year, September, like a bolt from the blue, we got the core judgment with which now even the formation of the panel is gone. So as on today, for the government, in the existing circumstances, arbitration does not appear to be a very attractive means of dispute resolution. But there are a few things that can be done. Number one, the statute 2019 amendment has created the Arbitration Council of India, which can do rating of arbitration institutions, which also provides accreditation of the arbitrators. And I think every arbitral award is only as good as the arbitrator. I think we need high quality arbitrators who are ethically very sound, their integrity is unquestionable, and they are known to have their expertise. They know the law very well. I think if we have a good pool of arbitrators whose ratings are good, whose accreditation is good, particularly through an institution, I think government can still have a look at going to arbitration as an effective means of arbitration. I thought these are my opening remarks. I can jump in whenever there is a need. Thank you, sir.
Thank you, Arvind, for voicing the concerns, the government and the background before which this decision was taken by the central government. Then we move on to the state government. What prompted them? Because what we have is only a circular, And the circular simply says this. I'll just read it out. Subject is incorporation of arbitration clause in government contracts, tenders, etc. regarding dated 16/11/2024. In exercise of the power conferred under Section 21 of the General Clause Act, the circular dated 10/1/2014 regarding incorporation of arbitration clause in government contract, tenders, etc. is hereby withdrawn with immediate effect. Now, in the public domain, we don't have anything more than this. So we need to understand from the state government what prompted them to go ahead and issue this circular, what was the discussion, what was the policy decision taken, etc. I think Kiran will be able to tell us better.
Thank you, sir. So now the circular dated 16th of November 2024, withdrawing the earlier government circular dated 10th of January 2014. Now, if you just take a look at the 10th of January 2014 circular, it was at the time when probably the Bangalore Arbitration Center came into existence. And to promote more arbitration, the government also said that we will include all arbitration clauses in government contracts. Now, sir, for last 10 years, and my limited experience of having handled a couple of arbitrations in last 2.5 years. In fact, just yesterday the state suffered an award of 65 crores in damages. When we thought the damages that could be awarded was somewhere between 5 to 10, but what came was about 65 crores as against 100 crore damages that was sought for. So now, what the circular, in fact, was also what made the government take a decision, or the challenges that we face when we defend the state, is the constant change in the officers who are well versed with the facts of the case, and then comes the counsel part of it. There's something known as the litigation conducting officer gets appointed for every case, and frequent transfers of those officers, and the counsel who represent also keep changing. And then there's a big gap in trying to understand, lack of information. So this is one major handicap which I foresee for the state too, and there's a non-level playing field when this aspect comes into picture. The second is the excessive claims, where I think largely the litigants are also partly responsible in making the government withdraw this, because the actual genuine claims are not put forth. Let us say, for example, if there are unpaid bills for about 10 crores, then the claim is to the extent of 300 crores. And 100 crores would be on a mental agony basis. And then the arbitrator also are very liberal when it comes to awarding damages. And when we see or scrutinize how the proceedings go on, although there are no cogent evidence placed by the claimant, more or less the award is based on the ground that there's no cross-examination, there is no, or there is a suggestion made. So they're looking to award claims when it comes to state. So these are factors that has gone into probably making the state take that decision. I feel that probably they can reconsider in trying to cap rather than withdraw the arbitration altogether. But now we also have commercial courts which are effectively dealing with disputes. In fact, one experience of our own office is where within 3 or 4 months there was a decree. So the commercial courts also have become an alternative. And the standard of proof that probably the civil courts apply and the standard of proof that the arbitrators apply are quite different now. And the grounds of challenge also, because of the limited grounds for challenge, that's also another area that the state is concerned about. So these are factors that has gone into making the government withdraw. That's what I see. There's also a note by the law secretary just following up with what the central government has said. That's one of the reason as to why the state has taken that decision. Probably they can relook and come up with a cap. That's probably my suggestion. Complete withdrawal may not be the solution unless there are other legal solutions that probably today that might emerge from the discussion.
Thank you, Kiran. Now, insofar as the first issue flagged by Kiran, transfer of officials, change in legal counsel, and due to that, on account of this happening, no proper defense being put forth. We see it in courts all the time. Instructions, lack of proper instructions, the performance of the government advocate and the government pleader is not as effective as it should be. I'm sure there must, if that is a concern, I'm sure there must be a way to address that and ensure that, I'm sure there must be ways to address. Transfers can't be obviously stopped, but there must be a way to address the person who gets transferred, briefing the incoming official, and the increase in, rather I would, with due respect to the government council who are already on panel, maybe more efficient government council, better effective representation for the government could be one way forward. Now, second issue flagged by Kiran is what we are now probably seeing in the motor vehicles era. What started off as inflated claims has now seeped into the arbitration claims. In motor vehicles, as all of us know, one ligament tear, we would ask 10 lakhs. And we ask for the moon and we get whatever we want. We would be the popular conversation which we all used to have. That people ask for inflated claims. You can ask for whatever you want. And the court fee doesn't change, especially in arbitration. Whereas in a civil, before a civil court, obviously it would change. That probably has resulted in this. And now asking, putting forth inflated claims is one thing. The real problem arises in the arbitral tribunals accepting claims without pleadings, without evidence, and based on a suggestion being put forth, given in the cross-examination, and non-challenged to one statement. For example, let us say the claimant's witness comes and says that we have incurred mental agony in a sum of rupees and we want 10 crores. Now, the cross-examining lawyer, the defense counsel, the government counsel, doesn't give a suggestion in relation to that question. Now, obviously, the tribunal shouldn't be relying upon the fact that there is no suggestion given in the cross-examination, there is no impeachment of that statement, therefore compensation awarded. Now, ultimately, this boils down to the quality of arbitrators. So if this one concern, then maybe that can be addressed in a little different matter. The third issue which you flagged was regarding the third issue. Awarding damages. That's what I was just, Kiran was talking about a case where they anticipated 10 crores as a maximum, and what was awarded was 65 crores without any proper pleadings and evidence. Now, this is something which is a part of the system, and it can't happen that, you substitute one arbitral tribunal and the next one performs better. So it has to happen all across, and institutionalized arbitration is probably the way forward. I think, as Arvind said, somebody who is accredited, whose profile is good, and I think, if I remember, Arun, as a lawyer, 10, 15 years back, you are an arbitrator. Probably we need to get in, okay, you're still a lawyer. I was only mentioning Arun's name only because I think we need to get in lawyers as arbitrators. That's probably one solution, one workable solution. Rather than looking at your traditional arbitrators, I think maybe getting in lawyers will give the government, the state government and central government some comfort, and this obviously will happen over a period of time. Over a period of 1 year, if they see honest awards, if they see arbitral tribunals operating with integrity, if they see arbitral tribunals not pandering to claimant lawyers, then I think the government will get comfort.
Right. Narrow grounds and Section 34 is another
Section
cause.
34 is another problem because commercial courts are delivering. Then you have straight away your commercial appeal, your COMAP, and COMAPs are being disposed of, I understand, very fast by the division bench. There's no second appeal after, it's only the Supreme Court. I think that is a big factor. No, not even talking about the state government. I think even claimants now are preferring to go to commercial courts. I'm told people are preferring to go to commercial courts only to avoid section 34 and 37. You go to the commercial court, you get a judgment and decree, ComApp gets over in one shot. It's probably one factor. Anyway, let me, instead of me trying to defend, I think I'll leave it to the, I'll leave it to Anand to, have your, to share your thoughts.
Thank you, sir. So, I think everyone recognizes that arbitration has its own inherent drawbacks, but there are various shapes and forms of arbitration. There is ad hoc arbitration, and we've seen clauses over the years. I've been on the transactional side drafting documents, so we've seen clauses change over the years. 20 years back, it used to be largely ad hoc. We'd put in a clause saying that 3-member tribunal, each party will choose one person and not send it to an institution. Over the years, institutions have, and some of them, I think it's been led, at least in my personal experience, largely with people adopting international institutions, and then realizing that that's working well, and then coming and reposing faith in domestic institutions. So the process of arbitration itself is something which, which is flexible enough to deal with the various issues that the government seems to be facing. We can't tell the government, no, you have to come and arbitrate. Like Mr. Kamath mentioned, if it is not palatable, party autonomy means that the government will not come to arbitrate, and you cannot force them to arbitrate. So we have to look at it in a more constructive manner, look at the issues that they're facing, and see whether or not those issues can be dealt with, not in an ad hoc way, but in a method that gives the government comfort that if it is entering into arbitration, the issues that it has seen in the past can be addressed on day one, knowing that when I enter into arbitration, I have at least some sort of a certainty that this is the process that's going to be followed. These are the kind of issues that have to be dealt with in arbitration. And if I fail or if I succeed in arbitration, this is where I'm going in terms of my legal recourse. Just the points that were raised itself, I'll just cover them very quickly. One is, of course, speed. And yes, the arbitrations in a lot of cases, especially when they were ad hoc arbitrations, getting the 3 arbitrators just asked to align to fix a next date, often would take, instead of in court, maybe your matters adjourned by 2 weeks or 4 weeks. In arbitration, it can get adjourned by 2 months and 4 months. But the various amendments to the Arbitration Act have tried to put forth at least a timeline, which by and large in our experience, arbitrators are trying to follow, because they don't want to face the issue of having to go to court and get the court to approve the 12 plus 6 plus after that, having the court to approve an extended timeline. Similarly, institutional arbitrations give you a timeline, and in my experiences, in most cases, the timelines are met, because the arbitrators on the panel there don't want to be seen as having a reputation for slowing down the process. There is some amount of accountability to the system itself. The next one, which we were again discussing, is limited grounds of challenge, and that's what Kiran just raised. There are ways, again, yes, there is, 34 is a limited jurisdiction. There are errors within the jurisdiction which cannot be corrected. It is supposed to be to correct perversity, which is an extremely high standard versus what we see in an appeal, for example, which gives you much larger grounds, both on facts and law. But even there, and people are looking at it, which is 2-tiered arbitrations, and the Supreme Court has, for example, upheld the 2-tier arbitration system, where you have an arbitration, and then if you're not happy with that award, you go to a 2nd tier, before you come to court with the limited jurisdiction that a court has under 34. So at Centro Trade, for example, the Supreme Court upheld in 2020, which is a 2-tiered system. So there are ways and means, if people put their heads down and look at it, to make it a better system, a more palatable system for the government. The third point that you had raised, sir, which is the fact that arbitrators itself, you have to look beyond the traditional arbitration, the traditional arbitrators. And we are seeing it happen more and more frequently, that you have counsel or senior counsel being appointed onto arbitral panels, onto arbitral tribunals, and them bringing in the rigor that that you may not see with some arbitrators. Of course, it goes back to horses for courses, looking at which arbitration requires who are on your panel. But the fact is that These are all issues that I believe can be surmounted, and I would want the government to come back into the fold of arbitration, especially in high-value arbitrations, because that is where, at least for us, we see that you actually need it's not that the courts don't have the ability. At the end of the day, most of our arbitrators are retired judges. They don't suddenly get ability after they retire. It's the lack of time and bandwidth, and that is seen more in international or other high-value arbitrations, where you need to have days which are dedicated to cross-examination of witnesses, as opposed to going to court, being ready for it, but the judge only being able to give you an hour and a half on the best day, and then gets adjourned by a week or 2 weeks, and then you come back and you have to restart the process. The momentum is lost. So I believe that high-value arbitrations are actually where the government needs to be, as opposed to just the lower-value arbitrations, where those matters actually can be dealt with much better in a commercial court.
Thank you, Anint, for sharing your thoughts. Let's move on to Purnima.
Thank you, sir. Thank you, everybody, for coming in on a Sunday morning to discuss this issue. The fact that we're discussing this on a Sunday morning itself, I think, means that it's important for us, and particularly at an arbitration
To
conference.
interrupt, it means government is working on Sunday also.
That means the government has a good team, sir. So I'm going to come back to that point to say that changing teams and competent teams are not the reason for withdrawal from arbitration. Let me start with mediation, because I think that's not been touched about a little bit on this. I think the central government circular that Mr. Kamath referred to is quite a detailed circular, about 6 pages, and if you do get the chance to read it, please do. It seems to suggest that the new Mediation Act is an alternative to arbitration. And in my view, it's not really the case. You really are pitching litigation versus arbitration. Mediation continues to be available to all of us. We should mediate. Mediation has interesting options. It's not necessarily related only to the law. We've seen some very high-stake conversations between principals where they then decide in the interest of doing business with each other. Suppose there's an investor who's come into India, is working with the government, wants to continue to work with the government of India or the government of Karnataka. They need to be in their good books, and they may settle, they may have a conversation. But at the same time, those of us who mediate regularly know that officers who are in mediation find it difficult to settle. They know that they're under scrutiny. They know that they cannot take a call. So whereas litigation and arbitration, they're told you do this, there is somebody who's deciding for you, whether it's the tribunal or whether it's a judge or it's a specialized government tribunal. But for them to take a chance, we've had repeatedly government IAS officers tell us, we cannot mediate, we cannot take a call. So whether this will then become a viable alternative to arbitration, I'm not sure. And this circular came out in 2024, where more than a year down the line, and we haven't seen much progress in the context of mediation with the government. We've seen progress with mediation, creative solutions coming out beyond the law in the interest of working together. So I'm not sure that mediation as the push in this context is the right focus, and happy to debate with the panel and the audience on that later. One other issue that we haven't talked about is confidentiality. A lot of investors who've come into India choose arbitration for confidentiality. They don't want to discuss how much money was invested in a certain project, what were the terms of that project in an open court. They choose arbitration and maybe institutional arbitration because this is within the 4 corners of that room where their dispute is being decided, who's going to be examined, cross-examined, what they say. So they are not keen for this to be in the public domain, and that's what was touted as one of the procedures. Party autonomy and flexibility are other core areas of arbitration. So today, if somebody decides to visit the site, that's possible in arbitration. You can have 3 technical engineers as your arbitral tribunal, people who may be very well acquainted with how a dam was built, for example. However trained your legal minds are, they will not know an engineer's perspective on a particular aspect of a weep hole or a specific idea of electricity. So I think there is some merit in having technical people in your arbitral tribunal, and you can choose, and party autonomy and flexibility gives you that option in an arbitration, which courts will not be able to give because that ability to change procedure is not key and is able. So I think this wholesale sort of rejection of arbitration is not really the way forward, which I know the panel is in agreement to some extent with, but these nuances have to be examined a little bit more. The Arbitration Bar of India, we do have an organization, there's an India Arbitration Forum, wrote back to both the central government and the state government to reconsider this position. In fact, when we were discussing this on Friday, the panel, there was actually a public interest litigation that was also filed in the Delhi High Court and later withdrawn. So there was great amount of concern amongst the arbitration bar. We've also seen in the past 20 years, there has been enormous progress, both domestically and perception of India as an arbitration hub. There is increasing faith in the Indian arbitration system. We've seen an increasing number of lawyers who know arbitration law. We've seen commercial courts support 34. So you were referring to 34 and 37. With the same speed, we've seen 34 not being entertained by the commercial court. We've seen the 37 disposed of. So within 3 months, we're out. We're clear. And we know that a good arbitral award has been supported by the judiciary. The Supreme Court has been supporting arbitration throughout. So when we've achieved this much progress through judicial precedents, through support, this is not the right time to withdraw. The last point that I want to make was also enforceability. There are more than 180 countries who are signatories to the New York Convention. So any international arbitration award can be enforced in any part of the world as far as the signatories. We don't have that flexibility insofar as judgments are concerned. We do have some relationships with some countries, but it's not the same kind of universal enforcement that arbitration has gotten to. So I think if there are issues, of course we need better arbitrators, and we've been requesting at the bar from Karnataka to the Honorable High Court saying when in Section 11, please do appoint senior counsel, please do appoint technically sound arbitrators, please don't look only to retired judges, and that as a community we will support in making that process better, and we continue to make that appeal. So I think there are small steps that can move forward, and a debate with the government, private sectors, through institutional networks would also help us understand what the concern is from the government side, so we can have this kind of conversation, more involved conversation, and hopefully there will be some attempt made to roll back these circulars. I'll stop here and happy to continue the conversation. Thank you so much.
Thank you, Purnima. Before I rebuttal, I hand over the mic to Arvind and Kiran for rebuttal. I think one thing that probably both the state government and the central government will never say is the success rate. Now, I'm sure what the bottom line was, 1,000 crores claim, 800 crores awarded. The government is convinced that 100 crores should have been the maximum. So there's a loss of 700 crores. I'm just giving this as an example. And arbitrations, claim petitions allowed, confirmed right up to the apex court. Through the process of arbitration, the government not being satisfied that justice was done on technicalities, legal restrictions, rather restrictions of Section 34, 37, they have lost out. And for them, in their minds, success rate is what, 20%? Is probably what they're not telling us. But it should have been 50%. It's probably 20%. So they have lost out more than what they anticipated. And therefore, there's obviously been a huge policy decision after enormous number of hours spent reviewing statistics, and the government has said, all right, compared to the courts where our success rate was higher, now we prefer to go back to courts. Now, with this, let me ask Arvind to respond to what both the panelists.
Sir, arbitration is indeed a very effective means of dispute resolution, and it is actually best suited for government disputes, particularly contractual disputes, because if the same disputes were to go to court, I can imagine how many days the evidence recording can go on. Because in arbitration, sometimes I have seen we have started at 10:30 in the morning and recorded the evidence till 4:30. I mean, the courts obviously cannot do it. But then you need to understand that the government has received a raw deal, particularly in the domain of grant of considering breach of contract and award of damages. And what the government has done is just a reaction to that. They have suffered bad awards, and which the governments feel if it was a typical, I mean, the conventional court system, they would not have suffered so. So all that we need to do is address those concerns. And mediation, I feel, although the Government of India circular says explore medium, I completely agree with Purnima that in the last, ever since the Mediation Act was brought in, I have not seen any significant traction in that domain by governments using mediation. That's because, in fact, our Government of India office memorandum also refers to it. In the course of any dispute resolution, let us say, sometimes there is an option that on a particular claim, both parties can agree, the government or the PSU can agree and agree. There is some sort of a fear that on behalf of the government or the PSU, if we agree now, then later an oversight body like the Auditor General may flag the issue. And so I think that is one area which needs to be redressed. There should be some mechanism to deal with that. In my experience, I have seen some officers, they would not take a risk of agreeing for a compromise or waiver of a particular claim or agreeing to pay the claim, even when the contractor has climbed down. They would say, rather, let there be an award. And we will face it, because the officers try to play safe. But then what happens is there is an award, then there is a challenge, and ultimately it will all steamroll into a hefty amount with interest added on it. So the issue is rather multifactorial. We need changes in the approach, we need changes in the mindset, we need changes in the law. So we need, which is why events like this are very, very important, where all of us, the stakeholders, come together, they discuss, there is public awareness, which ultimately results in changes in the policy.
Anything, Kiran, you want to add anything to what Arvind has said?
I fully concur with what, because
I
no
think-
officers will be able to take a decision with regard to mediation, sir. So
As Arvind was saying, it's not one single factor. It's probably the cumulative effect. End of the day, the government should, the reaction of the government, now, one thing is sure, it's not a knee-jerk reaction. It's not of the government. It's a well thought out, well considered policy decision, and they're not comfortable. See, basically, they're not comfortable that justice will be done, and therefore this is what they have done. And it's for all of us to, the claimants, the lawyers, and the legislature and the system itself, to give that comfort to this government, the state government and the central government, that look, even if you come to arbitration, it will happen fast and justice will be done, and the end of it, everything is as good as a judgment and decree of a civil court, but much faster, more efficient, and better for both the parties, especially when interest stops accumulating. Right. Anything further? Anand?
One more point I'd like to raise is the fact that if the government walks away from arbitration, what message does it send to private parties who are arbitrating? We have all these issues that have been raised, which may be systemic issues. Some of them eminently fixable. But the fact is that if the government says, I don't have faith in the system, the costs are too high, we are sending MSME to arbitration mandatorily. Statute imposes arbitration on various different, there are various statutory arbitrations that exist. MSME is just one example, small players being sent to arbitration. The Highways Act, for example, NHAI, mandatory arbitration. Large value arbitrations, again large value is going to arbitration. So if we don't look and fix, I'm not saying the system is working perfectly, but we need to look and fix the system so that everyone has faith in the process. And that process is dynamic. If you look at it, institutions, for example, amend their rules. The SIAC, for example, has amended its rules earlier this year to take care of feedback that has come from parties arbitrating. Similarly, the Arbitration Act has been amended multiple times to take care of issues that we have seen in the process of implementing arbitration. I think both Mr. Kamath and Kiran have said that we shouldn't be throwing arbitration out, the baby out with the bathwater. We need to fix the system. But it's important that both sides look at it and come up with solutions which work to take care of the issues of not just the claimants, but the respondents, whoever may be the claimant and the respondent.
Anything, Purnima, you want to add?
The last one point that I want to make is that I think it was Mr. Jaitley, when he was the law minister, who first mooted the idea of India as an arbitration hub. So making India as an arbitration hub came from the government as an idea. Now, if you are putting forth the idea that the world should come to India to arbitrate, then you must support it. And this has been the reaction it was coincidental that actually the London International Disputes Week was ongoing when this circular came out. And the Chief Justice had actually just made a statement in London saying India will become an arbitration hub. A few hours later, the circular came out, and there was a huge furor where the private bar was forced to sort of say, this is not necessarily the stand in all situations. So if we are to stop going to Singapore, if we are to stop going to London, if we are to stop going to Paris to arbitrate, and we're going to then tell people, please come to Bangalore, we're as good as people in Singapore, please come to Bombay, please come to New Delhi, we cannot have the Karnataka government or the central government saying, we won't arbitrate. That will sort of sit at crossroads. We need the full support of the government and the full backing of the government to make this city a hub. And we do have world-class lawyers here now. We have many young people who've gone, studied, worked in international firms, come back with good caliber and willing to work hard to make Bangalore a hub. So now is the time to push that envelope and not withdraw, is my final comment. Thank you.
I think everybody said what they have to say. Any questions from the audience? Plenty of questions.
Hi, good morning, everyone. I have one question. Sure, I agree that we need better arbitrators, but the issue of just better arbitrators and award may not be the only solution. My question is, what are the measures the government is taking to look inward, to look into its own system? Because there's also some bit of course correction the government needs to do. Whether it's arbitration or litigation, government needs to act. So what are the steps that the government is taking to look internally and inward into its system?
Can I ask both central government and state government to respond separately?
Yeah, can I just add to that so that because the same facet of the question. Now, when the government suffers an order, it is, we would expect that when you get 800 crore awards against the government or you repeatedly get awards against the government will put in place a mechanism for better contract management, for making sure that we have systems in place for how the contract is to be performed, that they don't delay on various fronts, they don't cause damages to other people. Now, we haven't seen any of those things happen, nor do we see changes with regard to the manner in which they're represented in these arbitrations. Do they come up with adequate documents? Do they provide documents to the counsels appearing? Do they give required assistance? Very often, even the feeling that government advocates have is that people in the government don't want this arbitration to go in a particular way. So therefore, keeping the arbitration in that particular course and not correcting course in-house seems to be more deliberate and probably a systemic thing. Those who are probably protesting are probably the ones who are putting out these notifications saying we ought not to arbitrate. But that really doesn't answer the question. So taking forward from Sneha's question, what systems are being put in place internally by the government? And let's not forget, the arbitration law is made by the government.
No, currently, insofar as defending the state in arbitration proceedings, we have about 5 lawyers now, myself, Santosh Gogi and Aditya Vikram Bhatt, who was former partner of AZB, and 2 other law officers who have been doing excellent job in defending all the arbitration proceedings. And I always feel defending state government, you just need to hit every ball for 7 runs, not 6. So although we are hitting all 6 runs, yet we are losing the arbitration. And of course, it's not because of that we are losing this arbitration. but also inherent defect that lies in so many aspects, as I just mentioned earlier, with regard to the information not coming freely to the lawyers. But also, when we take a decision not to contribute towards the fee because of the inflated claims, then we also notice that there is a bias that gets created as against the state by the arbitrators. So moment you say, sorry, the claim should have been 10 crores, but what is being claimed is 300 crores, and keeping in mind that this is the money that ultimately belongs to public, and you feel, no, we are not going to make the payment, then you see that element of bias creep in. That's one aspect, what I notice. The second is, of course, in few cases, I should not be, the proximity that the arbitrator gets with the opponent. The every kind of, the booking of the air tickets, hotel rooms, everything is taken care by the claimant himself personally. The institution does not play any role insofar as these aspects are concerned. That's another aspect. Thirdly, I feel when we say speedy disposal, there have been instances where the awards have been pronounced after 6 months from the date of reserving. And when you say the arbitrator is only dealing with our case and should be dealing with a couple of more, but 6 months is no justification to pass an award after concluding it or reserving it for. So I feel largely it's also because of the claimants who have not been truthful in their claims have also influenced the government to take this decision. And I think the law department probably will work towards examining all other aspects. And it's optional today. The state government has said that based on a case-to-case basis, there could be an arbitration. So it's not completely withdrawn itself. But as of now, because of the couple of awards that have come last 5 to 6 years, including, I think, the 600 crores, the Benny Mills case and other cases, have caused this reaction by the state government.
I think the question that Sneha and Arun raised is slightly different. In the sense, I think that's a very important question and a very difficult question for the government. I am now, as a law officer of the central government, other than the litigation policy and the June 2024 circular, the office memorandum, I am not aware what other internal systems are being put. But there are plenty of things which the government can do. For instance, number one that I have seen in my experience, other than the legal department of a particular department does not get involved until the dispute has gone to a court or an arbitrator. Till then, they have a hands-off kind of an approach. They work in different silos. So that should change. Involvement of the management or the higher management only when the matter goes to court. Actually, the topmost management will get involved only when there is an award. Till then, there is absolutely no involvement. If the entire office is involved, if they monitor the progress of the work, execution of the contract in time, a lot of things can be saved. And number two, there are various claims which can, if the management, the top management is involved right from beginning, can be discussed, deliberated and settled in some way. Only the real issues can go for arbitration or litigation. Thirdly, what kind of awards have to be questioned? There is litigation, there is a very well-defined litigation policy, but then typically there is a tendency to go and challenge to each officer to save his back, would rather take steps for challenging it to ensure, just to give an impression that yes, I have done my duty. But this is a domain or a sphere where a lot needs to be done by the government. There should be some deliberation and effective systems must be put in place to ensure that that can be one means of ensuring that arbitration is more attractive and successful.
Since the questions relate to matters of policy, we would like to invite some comments from Ms. N.B. Bhavani, Principal Secretary for the Government Department of Law and Justice on the
Good morning,
questions.
Milord, and all the other dignitaries who are present here. Milord, the government has issued the circular in not to invoke the arbitration clause at all. But as a law officer, we have given an opinion, it is an optional. One more thing, what I see is when I was sitting as a commercial court judge, I have come across one of the cases where the government has suffered an order, but the case is that the project never took up, never commenced at all, but the arbitrator has awarded the entire cost of the entire tender cost along with interest. What the government says, the government doesn't say that there is no fault on their part, but what they say is the award amount which has been awarded is exorbitant. The simple reason is, one more reason of the contract never took up is because of one of the MLA wants to give of that particular fund to some other project. So these are the consequences which leads to the government in a very difficult situation. I do understand, because as a judicial officer and as an arbitrator, because the arbitrator cannot go beyond the terms of the contract on one hand. At the same time, we sitting as a judicial officer, because we look into a lot of other aspects. I'm not saying this is correct or the arbitration is correct. This is just an opinion, because this is an open discussion here. So here, as a judicial officer, we would think about a lot of aspects: men and material, the investment made by the concerned contractor. And here, I'm not saying that the government is not saying that the contract is not terminated or the reason for terminations also. What they say is with regard to the quantum awarded. Is the quantum awarded is justified? Because when we sit under Section 34 of the Arbitration Act, we have a very limited scope. And this is another difficulty which the government is going to face. So these are the consequences which is leading to the government thinking about the other option, the judiciary would be the best place. Because yesterday we had a discussion, because even before, prior to the Hakim's judgment, there was no interference. Now, because of Gayatri Balaswamy, there's a little interference, but then also the interference is very, very limited. So these are the consequences, but when we try to convince the government saying that arbitration is a other alternative mode of redressal, so that is a best option, but still they are in a dilemma whether to take away the entire arbitration, which they can't do it because it is one more of alternative dispute resolution. This is what I would like to add up. And I agree with most of the what the government advocate says, our AAG and also the Assistant Solicitor General also. Thank you, my lord.
Thank you, madam. I think we have come to the end of the session. Any further questions from anybody in the audience? We saw a number of hands. One hand there.
Namaste. I'm an academician. I'm Anusha from Chanakya University, Bengaluru. Here, the question is, arbitration has so many advantages, like it is speedy disposal, and then it has experts coming and adjudicating the matter. And then, ma'am has said, in spite of there being so many advantages to this arbitration, why the people are not opting for it? One of the disadvantages that I see is the cost. You bear the cost of an arbitrator, and I often hear, I'll see you in the court of law, I'll sue you in the court of law. But then we never use this arbitration. Only we, the legal fraternity, know about arbitration, but as a common man, it's an alien concept for them. How to make it, whether mediation or the arbitration, popular, and because the West is moving towards ADR, and still the India is there in the litigation court system, this adjudicatory system. That is the question. Thank you.
All these conferences, ADR weeks, are happening only to popularize arbitration. And one reason why this topic, the entire session is, if the common man feels that arbitration is not a way to go, is one thing. If the government starts feeling it, it becomes worse. That's the reason, this entire discussion is happening. That to ensure that the government is comfortable with arbitration. The government looks at arbitration as how an ordinary claimant would look at. That comfort is what is essentially required. We have heard the reasons why the government decided to withdraw from arbitration, or wants to withdraw from arbitration, or reconsidering arbitration as one dispute resolution. And then we are only trying to tell the government that, look, all of us are with you. we'll ensure together as a team that you'll get justice, there'll be fair justice, and the justice, your grievances, even as a respondent, in most cases I think the government is a respondent, even your grievances will be addressed, your differences will be looked into, and you won't get a raw deal. I think somebody said raw deal. You won't get a raw deal, you'll get a fair deal. The entire conference, madam, is only to address that, and this session in particular. I wish to thank this.
So just one
sir.
comment.
Yes, sir.
In a lighter vein,
Right, sir.
the nomenclature arbitration and mediation must change, because arbitration is very close to the word arbitrary, and mediation is very close to the word meditation. So both these things should change.
That's right, sir. Sir, if the government were to meditate, then there won't be arbitrary decisions taken. On the other hand, if the arbitrators meditate and then deliver awards, I think there would be justice also. Right.
So,
thank you very much.
There's something that I missed some part of what Mr. Kamath said and then what Mr. Kiran said, but I don't know if this was necessarily discussed. I have been saying in various fora that we need to understand, when we say government, it's fairly amorphous. We need to understand who authored this policy, which gentleman or which body. Ask them to explain. And the body of lawyers, judges, we need to hear from them. We need to understand the factors which led up to this policy by reverse engineering the policy through the authors. I don't know if that debate has ever happened. That's not even a debate, that's a discussion. I think we are all trying to make inferences from the policy because the policy, of course, to some extent gives us the reasons for the policy. But I think it's very, very important for the legal community to sit with the authors of the policy, understand the sentiments directly from the horse's mouth, and then reverse engineer and see in which cases what has gone wrong.
Prashant, I am not sure if you had an opportunity to go through the official memorandum issued by the central government in June 24. It is self-explanatory. It methodically gives you the information as to why the government now thinks that for above 10 crore claim, arbitration is not an effective remedy. The government gives reasons for that. It also refers to, indirectly, that some sort of a collusion that can happen in arbitration because the judges conduct the proceedings in a very informal way, in a closed-door manner. It is not in the open court, and the selection of the arbitrator is not like the judges. They give reason. The bottom line is that the government felt that in view of certain consistent arbitral awards, it ended up spending a lot of money paying the contractors as damages along with interest. Now, if you look at government as a litigant, if I am the government and I am the litigant, I know I may have a policy to popularize arbitration, but at the same time, by virtue of the awards, if you make me suffer, if you bleed me with money which will far exceed the budget for any particular project, then I will not find it as an attractive means to pursue arbitration. So if you need the answer, you said you would like to hear from the horse's mouth, it is actually there. If you have a relook at the policy, it gives reasons as to why there is a shift from arbitration to mediation. Anyway, nevertheless, we have debated that mediation, although on paper may sound like a further alternative mechanism, but practically it may not be very effective. Arbitration with a little bit of tightening up of the belt and improvement of the system, wherein we ensure that good quality awards which are within the domain of the fundamental policy of Indian law, as is understood for section 34. If the government gets awards which fits into that, I'm sure government is going to have a relook at arbitration and find it to be an attractive means of dispute resolution.
Right. One more question, last question. Right.
One of the fundamental reasons for the parties to arbitrate is the exclusive time that we would get to adjudicate upon the dispute. Maybe does the government think that if there was no Hakim's judgment, or if the law were to permit the courts to intervene in such limited issues where the courts can replace its opinion, comprehensively deal with those limited issues where there is an evident perversity on the part of the arbitrator in passing the award, and to limit interference of the courts in such issues, and to replace its opinion to that of the arbitrator. Do you think do you think it would give some impetus to the government to consider arbitrations?
I'm not sure what exactly you meant, but then
I'm sorry,
the government's withdrawal is not based on the Section 34 court conducting a merits-based review.
No,
We all know that the law is very clear. A Section 34 court cannot conduct a merits-based review. It is only either breach of fundamental policy of Indian law or patent illegality. Broadly, these are the two avenues through which the court can interfere.
I'll just paraphrase the question. Just that the interference under Section 34 is very limited to the limited grounds which is provided under the very said provision. If we were to have a change in law, or by any judicial pronouncement,
What
if we
change in law?
change in law for the courts to interfere,
Widening the scope. Is it?
widening the scope under Section 34 and permitting the courts to replace its opinion only to the limited issues where there is perversity on the part of the award, and to replace its reasonings on such issues could...
I got it. In fact, with the permission of the chair, my own thought is that, now, please sit down. Why does the arbitration law say, give some sort of a finality to arbitral award? The fundamental object is that the arbitrator is the one chosen by party. A and B choose C, and they're bound by C's decision as far as the facts is concerned. Now, this was the fundamental logic behind making the arbitral award binding and final. If we go to a typical conventional justice delivery system, you file a suit, and then if you're unhappy, you can go to the appellate court. The appellate court can look into any issues of fact and law. But that is not so, because the parties had chosen. But if experience has shown that in most cases, both parties disagree on the choice of the arbitrator, and ultimately it is chosen by the High Court. Now, the High Court goes by the Section 11 code, just maintains a list and randomly picks up an arbitrator. It may not be the choice of both the parties. So, but then effectively there is a breach of that fundamental object that I referred to. It is not the party's chosen arbitrator. But this is a big policy decision which the parliament will have to consider, whether there can be extension of that very, very narrow avenue for the Section 34 code, that where there is perversity, the court can also conduct a limited merit-based review. I'm all for that.
I'm going to say I disagree with Mr. Kamath on that. And if you widen the scope of Section 34, please don't think of 34 courts only as commercial courts in Bangalore. Let's say we had a dispute of about 800 crores, a wind farm in rural Gujarat. The tribunal ultimately ended up 3 former CJIs of our country. But if it were to go to court, it would go to the local commercial court there. Imagine that judge being able to appreciate this situation, right? So where will it go? How will it happen? Who's your tribunal? That party autonomy should still remain if arbitration is to continue. If you don't want arbitration, step out of it, and that can be part of your contract at the initial thing. But to have a blanket withdrawal from arbitration is where the problem lies.
I wish to thank my co-panelists for this highly stimulating session. I hope by the time the next ADR week happens, that will be next year, maybe the government may change. Yeah, let's hope for the best. Right.
Thank you to the chair and our panelists. If I may request Mr. Arun Kumar to please felicitate the delegates on stage, please. Thank you to the chair and to the panelists once again. We can break for a short tea break. Tea is being served at the ground floor. And we will come back to the same venue for the parliamentary debate soon. Thank you.